Hello everyone, I am Nandita Nangia and I welcome you all to our YouTube channel CA Sansaar. So guys, recently Supreme Court has given a landmark judgment on educational institutions. So today we are going to discuss about the same, and for that we have with us CA IP Vivek Khurana ji. First of all, I heartily welcome you here sir, and thank you so much to be here today with us.
Thank you very much.
Before Vivek sir start his deliberation, I request you all to please subscribe our channel CA Sansar and also press the bell icon so that you will be notified whenever we post our new videos and webinars. It's over to Vivek sir now.
Thank you very much, Nandita, and to the team CA Sansaar for giving me again the opportunity. So you have rightly said, Supreme Court recently gave a landmark judgment on the profit-oriented educational institutions, and Supreme Court had overruled its two judgment. It's really important judgment. So we will discuss in brief because it's a very big judgment. So it's not possible कि मैं सारा आपके साथ discuss करूं. But yes, what's the crux of this judgment? That we will discuss. And let me show you through the PPT. If you are able to see, then please let me know. Is it okay?
Yes sir, it's okay.
So, profit oriented educational institutions, either it can be trust, educational society, or whatever, cannot claim income tax exemption under Section 1023C. This is the Supreme Court landmark judgment. And before that, my disclaimer is there. These all are my personal views and can't be construed the views of the ICI, CA Sansaar, or any other person or any other authority. And don't take it any legal advice, legal opinion, personal advice, professional advice, whatever. Don't take it that. And purpose of this video is to just spread the knowledge, information, awareness, and shall not treat it as solicitation in any manner for any other purpose whatsoever. And my request to all the viewers, please also go through the relevant section of Income Tax Act, relevant notifications, circulars, rules, and then also you can go through the judgment of the Supreme Court. I will also give you the link कि आपको पूरी judgment you can download and you can go through it if you have the time. So this is the landmark judgment of the Supreme Court. New Noble Educational Society, which is Chief Commissioner of Income Tax, and this is by the Honorable Chief Justice of India, UU Lalit ji, and Honorable Justice S. Ravindra Bhat and Honorable Justice P.S. Narasimha. उनकी bench ने ये landmark judgment दी है, and in this judgment they have said educational trust or society, whatever, etc., if they are seeking for exemption under Section 1023C, then this educational society or the trust should solely be concerned with the education or the educational related activities. तो यहाँ पे they have emphasizes on the solely. इसके ऊपर अभी हम और भी डिटेल में डिस्कस करेंगे. And they said if the objective of the trust educational society or the institution is the profit oriented, then you can't go for the exemption under Section 1023C. And they have also said, this is, I told you, very important judgment. एंड इसका जो पीछे क्या हिस्ट्री थी उसके ऊपर भी अभी मैं डिस्कस करता हूँ. एंड दे हैव आल्सो सेड इन द नॉलेज बेस्ड इंफॉर्मेशन ड्रिवन सोसाइटी ट्रू वेल्थ इज द एजुकेशन एंड एक्सेस टू इट. more and more focus on the education. And सुप्रीम कोर्ट बिफोर दैट 1023C है क्या, जो 1023C की जो हम exemptions लेते हैं under the income tax, it's that section 10 is for the exemption of income. It's the 1023C. इसमें है income received by an university or educational institution existing solely for education purpose and not for the purpose of profit, and which is wholly or substantially financed by the government, is fully exempt. Then another one is income earned by any university or educational institution existing solely for educational purpose and not for the purpose of profit shall be exempted from tax if the aggregate annual receipt of the such university or educational institution. So this is about the section 1023C, which is for the exemption of income कि आपको income tax से example मिल जाती है under section 10 में if you can apply to the income tax department. इसके ऊपर भी अभी हम डिस्कस करते हैं. So जो इसकी हिस्ट्री थी, एक आंध्र प्रदेश हाई कोर्ट की जजमेंट आई थी एंड दे हैव रिजेक्टेड द क्लेम फॉर रजिस्ट्रेशन अंडर सेक्शन 1023C टू द different societies and the different educational institution trust को they have rejected their claim कि it's not for the purpose of because this is not created for solely for the purpose of education. And after that, Andhra Pradesh High Court ने reject कर दी. And after that, many several educational trusts they approached to the Supreme Court against the judgment of the Andhra Pradesh कि please direct to the Andhra Pradesh or direct to the Income Tax Department कि हमें हमारा जो registration है under section 1023C में accept किया जाए. Then I told you already there was two ruling was there for the solely और सुप्रीम कोर्ट ने सिर्फ रिजेक्ट नहीं करी है एप्लीकेशन दे हैव आल्सो गिवन सम रिमार्क्स ऑन दैट वो रिमार्क्स क्या है एंड सुप्रीम कोर्ट इन दिस न्यू नोबल एजुकेशनल सोसाइटी वर्सी चीफ कमिश्नर ऑफ इनकम टैक्स दे सेड कि नो Andhra Pradesh is right. The purpose should be solely for concern with the education or education related activities. And अगर objective profit oriented है, then not able to entitle for the approval under section 1023C. ये पीछे भी हमने डिस्कस किया था और इसमें they have I told you overruled two previous judgment जो सुप्रीम कोर्ट की पहले दो जजमेंट थी वेयर दे हैव given the judgment on the reasoning and conclusion pertaining to the interpretation of the expression solely. तो पहले कुछ और मीनिंग था solely in their previous judgments. Now they have said it's a different from the previous judgment. And also Supreme Court said the since the present judgment has the departed from the previous ruling regarding the meaning of the term of solely and in order to avoid any disruption so supreme court said कि हम जो पहले की जो जजमेंट्स हैं उसको ओवररूल तो कर रहे हैं बट इट्स नॉट रिस्पेक्टिवली इट्स पर्सपेक्टिवली सो सुप्रीम कोर्ट सेड जो भी हमने लॉ डिक्लेयर इन द प्रेजेंट जजमेंट है शेल ऑपरेट पर्सपेक्टिवली नॉट रेट्रोस्पेक्टिवली एंड दे हैव आल्सो सेड कि वी आर गिविंग द टाइम टू देम कि दे कैन चेंज कि अगर जो भी है उनके जो ऑब्जेक्ट्स हैं दे कैन चेंज इट एंड जो समराइज मैंने आपको बताया ना अभी कि दिस इज नॉट कि उन्होंने सीधा आपकी एप्लीकेशन रिजेक्ट नहीं करी जो ट्रस्ट ने लगाई अगेंस्ट आंध्र प्रदेश हाई कोर्ट दे हैव आल्सो गिवन द रिमार्क्स तो जो समरी ऑफ द कंक्लूजन है तो दिस इज लाइक दे सेड all the object of the society trust etc must relate to imparting education or be in relation to the education activities to qualify the exemption under section 1023C कि आपका जो पर्पस है आपका जो ऑब्जेक्ट है दिस इज solely for education or educational activities not for the profit आपका पर्पस प्रॉफिट अर्न करना नहीं है बट एजुकेशन और एजुकेशनल एक्टिविटीज है एंड यू कांट से कि सम अदर ऑब्जेक्ट्स नॉट रिलेटेड टू ऑब्जेक्ट्स एजुकेशन सो दिस इज द ऑब्जर्वेशन कंक्लूजन ऑफ द सुप्रीम कोर्ट देन दे सेड the objective of the institution अगर उसके objective से profit oriented है if कोई institution है trust है society है if their objectives are profit oriented then that institution trust etc are not entitled to get the exemption under section 1023C and Supreme Court also said yes there can be surplus कि आपने कुछ surplus use किया in the given years या set of years में then there are no bar but that should be only with the provided education or educational activities आप ये नहीं कर रहे yes we are giving education and side by side we are doing this thing no solely for the purpose of education or educational activities then supreme court also said कि yes जो सेवन प्रोविजो है सेक्शन 1023C में या फिर सेक्शन 114A में दे सेड प्रॉफिट उसको भी दे डिफाइन प्रॉफिट व्हिच इंसिडेंटली जनरेटेड अर्न बाय द चैरिटेबल इंस्टीट्यूशन दे सेड this is if जो present case था that's those institution impart education or and engage in activity connected to the education ये भी उसी का part है and they said incidental to educational activities कि if you have they refer business and profit जो mention है seven proviso में they said this related to education जो आपने जो incidental educational activities है like कुछ बुक सेल करके कि आप जो सेल्स यूनिवर्सिटीज में या एजुकेशन इंस्टीट्यूट में दे सोल्ड द टेक्स्ट बुक या फिर कुछ स्कूल बस है या फैसिलिटीज है, हॉस्टल फैसिलिटीज है, दिस इज इंसिडेंटल टू द एजुकेशनल एक्टिविटीज, दैट्स ओके, वो दैट यू कैन अर्न, but this is related to the educational activities. And then Supreme Court said this is more power to the commissioner or the concerned authority by the Supreme Court. पहले तो they asked for the objects. They said while considering application for approval under section 1023C कि किसी को आपने approval देना for exemptions, then commissioner or concerned authority not bound to examine only the objects of the institution, कि उसमें सेकंड प्रोविजो में मेंशन है कि कमिश्नर को चेक करने हैं ऑब्जेक्ट्स ऑफ द इंस्टीट्यूशन, बट सुप्रीम कोर्ट सेड टू ascertain the genuineness to ascertain the genuineness of the institution and manners of its functioning, commissioner or the relevant authority, जो भी concerned authority है, is free to call audited accounts or such other documents for their satisfaction, for recording satisfaction, where the society, trust, or institute genuinely seeks to achieve the objects which are in prophecies. So now more and more power to the commissioner or the concerned authority. देख अगर आपने कोई सेक्शन 1023 एग्जाम्पशन के लिए अप्लाई किया है, then they can ask for the some audited accounts या some other documents to satisfy them. सिर्फ objects नहीं चेक करने. This is also the observation of the Supreme Court जो उनका conclusion है. Then they have also said कि in different states if there are some law, local law या obligatory requirement under state or law, then also that trust society or institution for the approval 1023 उनको वो भी अप्लाई करने हैं, एंड कमिश्नर एंड जो कंसर्न अथॉरिटी है दे कैन चेक फॉर द जेन्युइननेस ऑफ द ट्रस्टर सोसाइटी, कि अगर फॉर एग्जांपल किसी स्टेट्स के कुछ और प्रोविजंस हैं, कुछ और लॉ है in that state in addition to 1023C, then also that trust and institution have to comply that. So then they have another सुप्रीम कोर्ट दे सेड कि जो ये जजमेंट है हमारी, दिस विल बी प्रोस्पेक्टिवली नॉट रेट्रोस्पेक्टिवली. दे सेड the claim for approval or registration would have to be considered in the light of the subsequent event if any disclosed in fresh applications, कि अगर कोई फ्रेश एप्लीकेशन आती है उसी के ऊपर आपका एप्लीकेबल होता है, ना कि पुराने वाले जिन भी इनको रजिस्ट्रेशन दे रखा है. सो दिस जजमेंट विल बी प्रोस्पेक्टिवली. सो दिस इज रिगार्डिंग द जो लेटेस्ट सुप्रीम कोर्ट की एक बहुत इंपॉर्टेंट एंड लैंडमार्क जजमेंट है इन न्यू नोबल एजुकेशनल सोसाइटी वर्सेस सीआईटी सुप्रीम कोर्ट. सो आई होप नाउ इट्स क्लियर. जो भी एक समराइज वे में हमने डिस्कस किया है इसके ऊपर कि प्रॉफिट जो क्रक्स है, जो भी प्रॉफिट ओरिएंटेड एजुकेशनल इंस्टीट्यूशंस हैं या फिर कोई एजुकेशनल ट्रस्ट सोसाइटीज हैं, दे आर नॉट able to get the approval under section 1023C. So any other query, Nandita ji, you can ask or you can discuss. This is all about the latest landmark judgment. और जो इसका पूरी जजमेंट है उसका लिंक हम either into the description box or the comment box या फिर आप उसको CA संसार साइट पे भी अपलोड कर देंगे, you can download it.
Thank you so much, sir, for guiding us with a wonderful presentation. And a special thanks to our audience to be here today. And I request you all to please like the video and share it with your maximum friends so they can also get benefit through it. Thank you so much.
Thank you very much. Thanks a lot.